Hey, what's up everyone? Jonny Roven here, personal injury attorney. I'm so glad that you're going to check out this video. But first, I just want to tell you about my new text messaging platform. I'm now available by text. I'm building up a whole text messaging community. Just text me 818-639-3997. You can text me anything about personal injury. We're pretty much available all the time. Just try it out. Even test it, okay? 818-639-3997. All right, enjoy. Hey everyone, Jonny Roven here. Today I'm going to talk about getting certain evidence excluded from a trial. So there are certain types of evidence that obviously you don't want the jury to hear when you're going to a trial. Suppose you had some felony like 30 years ago, or suppose that a person has a drug abuse history, alcohol abuse history, some abusive relationship history. That's important stuff that, might not be relevant to a case. So you want to not have a jury hear that. For example, so I was involved in a trial earlier this year where there was a slip and fall, and one of the witnesses to the property, I think they were like in their 60s or something like that, and they had a couple felonies from like 30 years ago, 40 years ago, something like that, just so long ago. Some really bad stuff, armed robbery, whatever, just not good stuff. So we filed a motion in limine to try to get that excluded, to say, look, this felony is so remote in time, and if a jury hears this, then it's going to mischaracterize this person. Perhaps this person has changed. They haven't had a felony in 30, 40 years. Also, the jury might look at this person like, oh, we shouldn't believe what they said because they had this felony from so long ago. So the judge ruled that the felony is out and that topic could not be discussed in front of a jury. So that was very helpful to the case. I believe it ultimately helped settle the case, because now the defense wasn't able to mischaracterize this person and just point them out as being like this crooked felon. Another thing that you might want to get rid of is like alcohol abuse. So let's say, a witness, or if you're the plaintiff, you had a drinking problem like 10, 15 years ago. That's not something necessarily that a jury's going to need to hear. So what you might want to do is, have your attorney, assuming that you have an attorney if you're this close to trial, file what's called a motion in limine and explain that, this alcohol, you're sober now, and this alcohol abuse or whatever is going to be so prejudicial to your case. People are going to look at you in a poor light just because of a problem that you had, so long ago that has no bearing on the case whatsoever and no bearing on your future whatsoever. To try and get that excluded so that a jury doesn't hear it. It's very important to at least try to keep that kind of evidence out from a jury, so that they're not prejudiced into not believing what you say based on a problem that you or a witness may have had many, many years ago. So that's the talk for today. Motions in limine. Try and get evidence out of the eyes and ears of the jury, because once someone mentions it, it's very hard to unring that bell. Even if a judge says, please disregard what they said right there about them being an alcoholic. I mean, it's very hard. Once you hear something, it's very hard to unhear it, if not impossible. So very important tactic when you are about to go to trial. All right, good luck.